Now, the initial meeting that you have with an attorney in a divorce action is extremely important for a number of reasons, and primarily two. Number one, to make sure that the attorney is comfortable with you, and most importantly, to make sure that you are comfortable with the attorney. At that initial meeting, we're going to discuss many things relating to your marriage. We're going to talk about assets. We're going to talk about debt. Sometimes people think that if they have an asset solely in their name, or if there's a debt solely in their partner's name, that does not become part of the marital action, the divorce action, and that's not necessarily true. There's a presumption in the law that any assets or debt accumulated, with some exceptions, during the marriage are marital property. And there is what's called separate and marital property. Separate property can be anything that you bring into the marriage. As I just indicated, marital property is anything that's accumulated during the marriage. Now, there are occasions where separate property can be commingled, meaning, for an example, if you were to receive by way of a will certain monies, you inherit some money, and then you take that money and you deposit it into a bank account that has the name of you and your spouse, and you both are depositing your incomes into that same bank account, and you use that income from that joint bank account to purchase property, you may be commingling the property. So that's one thing that we want to talk about at the initial meeting, to see what is truly separate property, what is marital property, and if there is separate property that's been commingled, we want to talk about whether we can set up a paper trail to get you a credit to show that that is your separate property, and that's something that in the divorce action at the end of the day you should get a credit for and should be solely yours. Another thing we're going to talk about at the initial meeting is spousal support. In New York, there's two types of spousal support. There's pre-divorce, pre-judgment spousal support, and post-judgment. With spousal support pre-divorce, there's actually a formula that's set forth in the domestic relations law, New York State domestic relations law, which comes out with a presumptive number. The courts always have the ability to deviate for certain reasons, but you can make an application for spousal support if obviously you're the less income spouse. As it currently stands in the state of New York, for post-divorce spousal support, there is no formula. Rather, the court has to take into consideration many factors that are spelled out through the domestic relations law. So we're talking about not only the amount of spousal support, but we're also talking about the duration. A hot topic in any divorce action is going to be children. If there's children involved that are not emancipated, meaning generally, they're under 18 or under 21, there's going to be a lot of issues surrounding the children. We're going to have to deal with custody. Are we going to be having an arrangement where there's sole custody, or is there going to be joint legal custody? And is it possible that there might be joint physical custody? And by that I mean there might be an arrangement where you have two parents that can really work together in the best interest of the child, where they have a split time arrangement with the child. If you don't have that sort of situation, we're going to be looking at visitation. What sort of visitation arrangements are you looking for, and what's best for your children? And there's a lot of things to take into consideration when dealing with visitation as well. Some things people don't think about. For example, you might want to take a couple vacations every year, but the way your visitation arrangement might be set up, you might not be able to do that because it would interfere with the non-custodial spouse's visitation. So there's a lot of things we look for when developing a visitation arrangement or visitation schedule so that your time with your children are protected. Likewise, we're going to be focusing on child support. Just like pre-divorce spousal support, there's a formula for child support, and that's applicable both before and after the divorce action. They use the same formula, and there's different percentages that pertain to the amount of child support depending on the number of the children. At the end of our initial meeting, after we talk about the assets, the debt, spousal support, child support, and other issues relating to your marriage, we're going to hand you a packet of papers, which is called a statement of net worth. And it's approximately 10 to 15 pages long. And for a lot of people, it can be the most tedious part of a divorce action. And through that packet of papers, you have to list each and every expense you have. And when I say each and every, we're looking at food, entertainment, alcohol, videos, music, hobbies, anything you can think of, along with each and every asset you have. And these statements of net worth have to be sworn to, and they have to be exchanged between the parties in every matrimonial action. Now, after you've secured the services of an attorney, you have to make a decision as to how you're going to initiate this action. And at our firm, we focus on two different methods. One method, obviously, is you file a lawsuit. You file an action for a divorce at the clerk's office. And it's just a couple pieces of paper. It has certain automatic restraining orders which prevent the spouses from disposing of assets or racking up debt, except for limited purposes. And sometimes it can be advantageous to file that piece of paper. For example, if you think that your spouse is going to start draining accounts or transferring funds, if you file for divorce and you have him or her served with the divorce papers, these automatic restraining orders would prevent him or her from disposing of any assets. A lot of times what we'll explore doing with our clients, because most people don't want to go to court. It's scary for people, it's not normal for them, and we get it. So sometimes what we try to do is see if we can work out a resolution to your matrimonial action that would basically end with you never having to step foot in a courtroom. So what we might do, we might send a letter to your spouse. It's very soft, it's respectful, saying that we represent you. We request that either you get an attorney or advise us in writing that you're going to be representing yourself, and try to work it out of court if possible. That's not always possible. So if we can't do that, if we can't get an agreement, and what we would generally do if we're able to reach an out-of-court resolution, we would draft up a separation agreement, opting out agreement, settlement agreement. It means the same thing. It's basically a contract which sets forth your respective rights and obligations stemming from the marriage. But if we can't get that done, and we have to initiate a divorce action, there's many steps that go along with that. Again, we have to file the divorce papers. Once we have the divorce papers filed, then we have to get a process server, usually a private investigator that we use, and that person will go out and actually serve your spouse. Hopefully your spouse will then get an attorney, or they'll advise us in writing if they're going to be representing themselves. After that, we file a piece of paper called an RJI, which is short for Request for Judicial Intervention. Through an RJI, what we're asking the clerk's office to do is to assign a judge to your case. And it's random. There's 3 or 4 judges in Broome County that'll be assigned divorce actions. So we file an RJI, the case gets assigned, and we get notified of which judge has your case. After that, the judge assigned will send a letter to us advising as to when there's going to be a preliminary conference in connection with your divorce action. And all the parties and attorneys attend the preliminary conference, where the judge will explain to you how things are going to proceed through the divorce. And at that preliminary conference, the judge will set very important dates. He or she will set dates for the completion of discovery, where we can file discovery demands to get certain documents from your spouse, bank records, deeds, emails even, photographs. Likewise, we can conduct what's called depositions, where we would bring your spouse into this room actually, and we would question them under oath so that we can get all the information that we need to effectively represent you. In addition to giving us a date for completing discovery, the judge will give us dates to file what's called statements of proposed disposition. And what these documents are, and it can be anywhere from 5 to 15 pages, we're laying out to the judge, we're giving him a preview of what we think our evidence will be at trial and how we think that your case should be resolved. And both parties get an opportunity to do that. The judge will also give us a date to file what's called a note of issue, certificate of readiness, basically another piece of paper where we are representing to the court that we're ready for trial. And likewise, some judges will give us a trial date at this preliminary conference, some won't. But that's generally what's going to be happening at your preliminary conference. Settlement negotiations can occur from the moment you retain us all the way up to and including through the course of a trial, even after a trial if a decision hasn't been issued yet. But if a settlement can't be reached, we proceed to trial where we represent you. Your spouse will either represent themselves or have an attorney represent them. And at the trial we can present witnesses, we can have you and or your spouse testify, and we can present documentary proof as well. And after the trial is concluded, the judge will usually take about 30 days to issue a decision as to how the assets are going to be divided, how the debt's going to be divided, who's going to have sole or joint custody, who's going to have visitation, what's going to be the amount and duration of spousal support, and what's going to be the amount of child support and things of that nature. The goal of our office is simple. We want to achieve a fair result for you and the best result. The playing field for reasonable resolutions in divorce actions are pretty wide. And what I always tell prospective clients and clients in matrimonial cases is this. No one knows your personal finances and or your children better than you and your spouse. And I always think it's great if you can have two people that know their finances and know their children better than anyone, if they can work it out, if they can talk and try to come to a reasonable resolution. And so long as you're happy with the resolution, and so long as we think it's in the playing field, we'll tell you that we think that's a fair way to resolve your case, and that's what you should do. If we think you can do better, if we think you can do worse, we'll let you know. But at the end of the day, it's your decision because it is a very personal matter. We have a very family-oriented practice at Jackson Bergman. We understand that divorce actions going through this can be one of the most difficult periods in someone's life, and we're very sensitive to that. We try to make ourselves available to people almost every day of the week, every hour of the day. But we care about our clients and we do the best we can to achieve the most favorable results for them.